Thank you. Good afternoon, Council and parties present. We are ready to begin. May I know who is appearing for the applicant? Good afternoon, Council.
This is Team CB01 appearing on behalf of the applicants.
Your name?
My name is Asma Mohammed, and I shall take 13 minutes of this honorable court.
Okay.
And my co-counsel is Mr. Philip Moya. He shall be taking the next 14 minutes of this honorable court. And we respectfully reserve 3 minutes for the rebuttals.
That's right, Council.
See work permits and issue D on the principle of non-refoulement, and thereafter conclude with our prayers. We respectfully reserve 3 minutes for the rebuttals. Unless directed otherwise, I wish to proceed. Your lordships and ladyships, this case began with a cry for help from Amina, whose ID card was seized so she could not even complain. From Samuel, whose blood stained the factory floor. From Fatima, who was locked behind iron gates as night fell. But Javari did not listen, and when a state stops listening, it stops governing by law. On issue 1, the question before this honorable court is whether it has the requisite jurisdiction to hear and determine the present reference. We submit that this honorable court has the requisite jurisdiction to entertain the present reference. The legal basis for jurisdiction of the East African Court of Justice is grounded in Article 23 and Article 27, sub-Article 1 of the EAC Treaty, and is interpreted by this honorable court in the case of East African Civil Society Organization Forum versus Attorney General of Uganda. There are 4 types of jurisdiction, namely temporal jurisdiction, subject matter jurisdiction, territorial jurisdiction, and personal jurisdiction. On personal jurisdiction, your lordships and ladyships, and Article 30, sub-Article 1 of the treaty, all natural and legal persons resident in a partner state can bring a reference before this honorable court. The applicants, all residents of the Emara African Council, and the respondent, a partner state, the Republic of Javari, squarely satisfy this requirement. On territorial jurisdictions, your lordships and ladyships, the act and omissions complained of occurred wholly within the territory of the Republic of Javari. Thus, it is our contention this honorable court has the requisite territorial jurisdiction to entertain this reference. However, members of the bench, in contention today is the temporal jurisdiction. We anticipate the respondent may seek to challenge temporal jurisdiction on the basis that this reference was filed outside the 2-month limitation period, contravening Article 30, sub-Article 2 of the treaty. However, we would like to submit to the contrary that indeed this court has the temporal jurisdiction to hear and determine this matter. Members of the bench, the starting point in this case is understanding what a cause of action has been defined to be. A cause of action, as interpreted in the case of Omar Awad was Attorney General of Uganda, is a state of fact which gives a potential claimant the right to bring a claim against a potential defendant. This court went further on to clarify the time, and Article 32 begins to run from the date of the act enactment, the date of the act, directive or decision complained of, or from first when the claimant acquired knowledge of it. Your lordships and ladyships, we seek to rely on that second limb. Our case is not about the enactment of the RIA, the PPRPF, and the ERSA. Our case is about the Republic of Javari's subsequent failure to provide effective remedy for the violations arising out of their implementation. This very court, in the case of Mother Karua, was Attorney General of Kenya, held that a cause of action can arise out of the failure of the state to act through its judicial machinery. Across the fact pattern, the applicant and other human rights defendants repeatedly sought redress through every single domestic avenue available. Pursuant to paragraph 29 of the fact pattern, this matter was filed with the ombudsman, who did nothing. Pursuant paragraph 34 of the fact pattern, the Ministry of Humanitarian Affairs failed to investigate the severity of this situation despite it being their mandate. And finally, public interest lawyers and human rights organizations filed consolidated petitions before the High Court of Javari, challenging arbitrary detention, withdrawal of black work placement, and denial of refugee permit. Yet, your lordships and ladyships, nothing happened. No response, no hearing, and no judgment. It is at this point that a new course of action crystallized under Article 30, Sub-Article 2 of the treaty. This denial of remedy is our cause of action, members of the bench. Turning to subject matter jurisdiction, this honorable court in the case of Plaxeda Rugumba versus Attorney General of Rwanda held that although the EACJ lacks express human rights jurisdiction, it will not abdicate its role of interpreting the treaty under Article 27, Sub-Article 1 of the treaty if the reference contains violations of Article 6D and 7.2 of the EAC treaty. Members of the bench, our case today concerns the blatant violations of this very principle. It is our submission that this honorable court, pursuant to Article 27, Sub-Article 1 of the treaty, has the requisite subject matter jurisdiction to entertain the present reference. And as such, member of the bench, on issue A, we submit that this honorable court has the requisite jurisdiction to hear and determine this matter. On issue 2, the question before this honorable court is whether the RAF, the PPRPF, and the ERSA violates Javari's obligations under Article 6D and 7.2 of the EAC Treaty. Article 6D mandates partner states to uphold the principles of good governance, the rule of law, and the promotion and protection of human rights standards. And Article 7.2 mandates partner states to govern in accordance with those principles. We submit that the respondent state has blatantly violated those principles. Our submissions shall proceed in two key limbs. First, on the failure to promote human and people's rights, and second, on the violation of the principle of the rule of law. Turning to my first limb, Article 6D mandates the states to ensure practical and effective enjoyment of human rights. The Republic of Javari violated this in violation of both treaty and international law. Members of the bench, among the many rights violated, we seek to draw this honorable court's attention to the right of access to court. Under Article 16 of the 1951 Refugee Convention, a refugee must be granted free access to court and be treated on the same footing as a national regarding legal assistance and procedural protection. This right is further espoused in Article 7.1a of the African Charter, which grants every person the right to have their cause heard, and Article 14 of the ICCPR, which protects equality before the law. Members of the bench, the applicant sought remedies through domestic avenues. However, the very doors of remedy were locked. Take Amina Yusuf, as seen from paragraph 19 of the fact pattern, a refugee who was assigned to the special economic zone with no written contract, her identification document withheld, and without it, she could not even file a formal complaint. Samuel Damini worked 12-hour shifts under exploitative working conditions when he was injured and asked for medical help. He was threatened for being reported for non-compliance with the work program. And lastly, Fatima Elmi, a single mother, had her wages withheld and was locked inside factory compound for hours. She tried to report the abuse, but Worklink's grievance channel was non-functional, as correctly noted by paragraph 20 of the fact pattern. Members of the bench, if that's not enough, when reports of detention and torture under Haven-Link authorities reached the Ministry of Humanitarian Affairs, the Ministry of Humanitarian Affairs failed to investigate the severity of this situation, as painfully noted by paragraph 34 of the fact pattern. Lastly, public interest lawyers and human rights organizations filed consolidated petitions before the High Court of Javari, but their petitions were left hanging in consolidation. Their relief lost to delay, as seen by paragraph 43 of the fact pattern. And as such, members of the bench, it is our submission the Republic of Javari, by the failure to respect human rights, violated Article 6D and 7.2 of the EAC Treaty. Turning to my second limb, on the violation of the principle of the rule of law, members of the bench, this honorable court has been clear on what the rule of law requires. In the case of Henry Kyarimpa versus Attorney General of Uganda, this very court held that arbitrariness strikes at the very heart of the rule of law. Similarly, in the case of Democratic Party versus Secretary General of the ASC, this honorable court violating refugees' rights is in violation of Article 6D and 7.2. And we pray that this honorable court issues a consequential order to the Republic of Javari to amend these legislative frameworks to bring them in conformity with Article 6D and 7.2 of the EAC Treaty. I shall now cede the floor to my co-counsel, Mr. Philip Boyer, to address this honorable court on issues C and D.
Thank you very much, Counsel. Before your colleagues comes on, may I find out from the lordships and leaderships on the bench whether there is any one of us who has any issue that requires clarification by Counsel?
Yes, Presiding Judge, I have just two questions. I wanted clarification from the Council. The question of the task forces that were constituted, do they have any impact on your argument on violations? And also the state made reservations. So does that also have an impact on the violations that you are mentioning? And you also talked about abrogation of sovereignty. I would like to hear your comments on whether there is any supporting law on that. Thank you, Presiding Judge.
Thank you, my lord. Any other? All right, I think we are good to go. Counsel, you may respond accordingly.
In answering your first question, Professor Edwin Abuya, allow me to direct the attention of this honorable court to paragraph 43 of the fact pattern. And allow me to read in verbatim. Dissatisfied with the slow progress domestically, the applicants publicly voiced their concerns on global media such as the CMM and BBC. Under pressure, the government of Javari promised to establish a refugee rights task force to review complaints and recommend reforms. It is not until this matter went before the ERCJ on 5th June 2025, after months of cries by the refugees in Javari, when the government of Javari formed a refugee rights task force on October 2027. And as such, Your Excellency, it is our submission that by the denial of justice and the delay of these remedies, that Javari was complicit in violations of Article 6D and 7.2. On answering your second question on abdication of sovereignty, Javari delegated settlement management, basic services, and labor allocation to Havenlink and Worklink Solutions. Allow me to direct this court's attention to the case of Seraki v. Nigeria, particularly in paragraph 44 and 57 of the fact pattern, where a state has three tripartite obligations: the obligation to respect, the obligation to protect, and the obligation to fulfill. The obligation to protect entails the state redressing violations which are committed by private actors. In our present case, we see how Javari incentivized Havenlink and Worklink to provide these services to refugees. But once these very actors tortured, exploited the refugees, the Republic of Javari failed to investigate, failed to provide remedies, and failed to provide reforms. And as such, the private inaction by Havenlink and Worklink turns the state of Javari responsible by their failure to protect. On your third question, Professor Edwin Abuya, we do note that the state has made a reservation to Article 17 of the 1951 Refugee Convention. However, we do allege that the respondent state has violated Article 16 of the 1951 Refugee Convention of the refugees' right to access to court, and as such, they still remain complicit. Thank you.
Thank you very much, Counsel. Well articulated. Can we have now your colleague, Mr. Mboya?
Judge President, distinguished members of the bench, I hope I am audible. Judge President, distinguished members of the bench, good afternoon, and may it please this honorable court. My name is Philip Thomas Mboya, and in the course of 10 minutes, I will address the merits of issue C and D as the second counsel of the applicants. Honorable members of the bench, in the midst of my submissions, you'll begin by hearing the absurd, proceed to the unlawful, and end with the unthinkable. Before I proceed, there was a concern that was raised by the court with regard to the reservation that has been made by the respondent state with respect to Article 17. Your Excellency, it is our contention that under issue C, we are not challenging the reservation. However, we are challenging the obligations under Article 15 of the African Charter. Your Excellency, and turning into my first issue of my submission, the African Charter states that every individual shall be guaranteed the right to work. However, Your Excellencies, the respondent state is not fulfilling that part. An interpretation of Article 15 in the case of Institute of Human Rights and Development in Africa versus the Republic of Angola has interpreted individuals to include refugees. Paragraph 44 of SERAC versus the state must refrain from directly violating this right. Allow me to turn you to the unfortunate situation that is in the fact pattern. Your Excellencies, under paragraph 25 and 26, the respondent state is misplacing this refugees file let into the labor market. However, the respondent state has resorted to one, arbitrarily misplacing these files, placing a time delay, or refusing their files in the name of national interest. Excellencies, again, this is not conscionable. We anticipate that the respondent may attempt to argue that they have preserved Article 17 of the 1951 Refugee Convention. However, as displayed by paragraph 44 of the fact pattern, they are signatories to the African Charter. Therefore, they do have obligation to protect the right to work in respect to Article 15 of the African Charter. As I conclude on the third issue, the applicants pray that the court finds that the respondent state is indeed in contempt of the right to work under Article 15 of the African Charter. Moving swiftly to the last issue of determination before this court, the question raised is whether the safe third country transfers to Ulukari violates Javari's obligations under international refugee law. The applicants submit that first, Javari has a condition to take in these refugees under Article 33 of the 1951 Refugee Convention, and the transfer of these refugees to Ulukari is a blatant violation of Article 23 of the OA Refugee Convention. Turning to my first limb, Javari has an obligation to take in these refugees and create conditions where they may not feel like they have to return to a state where they may face danger. Your Excellencies, non-refoulement under Article 33 of the 1951 Refugee Convention states that refugees should be taken in by a host state and not transferred to a state where they may face risk or any foreseeable harm. The basic standard that is demanded of the host country is that they should provide effective protection to these refugees. Effective protection, as defined by paragraph 343 of the case of MSS versus Belgium and Greece, assesses whether, first, the recipient state is protecting these refugees from the threat to life or liberty. Second, the refugees have access to basic rights. And finally, can a person challenge the violations that have occurred in the camps under an impartial body? Allow me again to turn you to the unfortunate situation in the fact pattern. Drawing from paragraph 31 of the record, it is clear that these refugees who are in Dukara and Bakama camps are facing dilapidated conditions. Haven Link has resorted to selling humanitarian aid. Your Excellency, they are facing a threat to life and liberty. To the second subtest, they have no access to the basic rights. From paragraph 32 of the record, the refugees cannot access healthcare and they cannot access food. Your Excellencies, Haven Link has resorted to sell this food to the refugees. Humanitarian aid cannot be sold. Your Excellencies, again, it is unconscionable. In the case of MSS versus Belgium and Greece, the court stated that if refugees are staying in subhuman conditions, then it is a violation of Article 3 on dignity in the European Convention. Similarly, to the fact pattern from paragraph 32 and 33, these refugees are going through a sad state of affairs, being sold their healthcare and their food. From paragraph 33 of the record, we can observe that these refugees have also, particularly children, have resorted to early marriages or forced to drop out of school in order to take care of their subsistence. Again, Your Excellencies, it is unconscionable. Driving to the second limb of my arguments, we contend that the transfer of these refugees to Ulukari is chain refoulement and a blunt violation of Article 2.3 of the OAU Refugee Convention. Chain refoulement, as defined by the case of MSS versus Belgium, particularly paragraph 341, states that it occurs when a state sends a refugee or an asylum seeker to a third state without any assessment of the real risk. The court went forward in paragraph 344 of the same case to state at first, the state should assess individually whether the person being risked in the third state. Second, if the third state provides effective and genuine care for these refugees. And finally, if the transferring state substantially contributed to the harm that these refugees are going through. On the forcibility test, from paragraph 15 of the record, the refugees have been sent to the Ulukari Uwezo camp, where Javari is aware that they will face coercion, constant surveillance, and confinement, a deprivation of their liberty and freedom of movement. The African Institute of Human Rights and Development versus Guinea, it is very clear that arbitrary monitoring is a threat to the protection obligations that are espoused under Article 2.3 of the OAU Refugee Convention. Turning to the effective protection case, as displayed by paragraph 14 and 15, Ulukari has denied the freedom of movement of these refugees. Allow me to turn your attention to the case of Hurilos versus Nigeria. Your Excellencies, a detention center or a facility is defined as a detention center if first, the refugees cannot live freely. Second, there's continuous arbitrary supervision. And finally, there's an administrative delay without any justification. And even if the fact record has stated that it is not an arbitration, it is not a detention center, if it missed these three tests, then it is indeed a detention center. From paragraph 14, we can see that Ulukari has denied these refugees from leaving the camp without any justification. There's continuous supervision by security forces, again, without any justification. And there's an administrative delay, and refugees can stay there for as long as 3 years, contrary to what the respondent has put in their laws, that they should be there for only 6 months. Excellency, again, this is unconscionable. On the causal link test, we can see that through the respondent's actions under paragraph 10 of delaying these refugees' transfers, then they're going through irreparable harm of their right to work. They cannot justify to why this delay is imputable to us or the third state. And as such, Your Excellencies, on the fourth issue, we pray that you take note that this Safe Third Country Agreement is a blatant violation of the non-refoulement obligations under Article 33 of the 1951 Refugee Convention. Judge President, Honorable Justices, as my co-counsel and I began, we informed you that this case will begin from the absurd and end with the unconscionable. In light of our submissions, we pray that, first, the court has requisite jurisdiction to hear and determine this matter. Second, that the relevant acts, that's the PPRF, ERSA, and the RIEA violate Article 60 and 7.2 of the EAC Treaty. Third, that the respondent state is violating its obligations to international and regional law by issuing late permits of the Class C work permits. And finally, that the Safe Third Country Agreement between Javari and Ulukari violates international refugee law. Thank you, and I cede the floor back to the bench pending any questions.
Thank you very much, Counsel. Let's see whether the court has any.
Presiding Judge, I
Questions,
just
yes.
have one question for Mr. Mboya, Counsel. On paragraph 14 of the fact pattern, there was a grant of $600 that was going to be payable. In as much as you talk about the violations, what's your take on that? And then number two, you talk about the least restrictive measures, and you cited an EU case. I wonder whether you have a local authority that nails the question about the least restrictive measure. Thank you, Presiding Judge.
Thank you. I take note of the concerns that have been raised by this court. First, on the effective protection obligations by the state. Your Excellency, as noted by paragraph 44, you are right that the respondent state has indeed provided $80 million in developmental aid and $600 per refugee for the refugees who are staying in Olukare. However, as noted by paragraph 4.3.1 of the 2008 Note to the Safe Third Country Principle, financial assurances cannot substitute for protection obligations. And that is our contention before this court today, that the respondent state is attempting to substitute its protection obligations by giving financial assurances to the state of Olukare. On to the second question, on the local authority for the EU case that we have used. Your Excellency, it is our submission that in the case of Margaret Ziwa versus the Secretary General of the ESC, they have relied on an EU case there in order to come up with a ruling. And as such, we pray that this court will rely on the directive that we have given in order to come up with our ruling. Thank you, and I cede the floor back to the bench, pending our 3 minutes of rebuttal.
Thank you very much. Is there any other? Thank you. Don't think we have. Thank you.
President Judge, your lordships, your ladyships, my name is Abraham Baraka Wanyanga, first counsel for the respondent. I appear here today with my co-counsel, Namanya Christia Abigail. We have been granted 30 minutes of this honorable court's time. In 15 minutes, I shall respond to the applicant's submissions on issues 1 and 2. In the further 15 minutes, my co-counsel shall respond to the applicant's submissions on issues 3 and 4. Your lordships, the respondents before you today are a victim of their own generosity. In seeking to co-opt the private sector in the provision of services to refugees and in the management of refugee affairs, the respondent state has found itself the unfortunate victim of litigation before you. As we shall demonstrate in our responses to the applicant's arguments, our efforts are a good faith discharge of all our treaty obligations, both regionally and internationally. Your lordships, allow me proceed to our responses. Issue 1, as the applicant noted, concerns whether or not this court has jurisdiction to entertain the present reference. We agree with the applicant's submissions that indeed this court's jurisdiction is of 3 parts: temporal, material, and personal. However, your lordships, we disagree with their characterization of how this reference meets the standards in law under temporal jurisdiction and personal jurisdiction. Your lordships, Article 30, Clause 2 provides a strict jurisdictional requirement of 2 months from when the cause of action arose or from when the cause of action came into the knowledge of an applicant before a reference is filed in this court. The applicant attempted to lead court to assert that the real issue that crystallized the reference was the supposed failure of the courts of Javari to grant them remedies. However, your lordships, a simple look at the wording of issue 2 shall show that the heart of the applicant's submissions is the provisions of the RIEA, the ERSA, and the PPRPF. Indeed, as they traversed the second issue, your lordships, they focused on what the laws say and what outcomes they enable. Your lordships, that established, we shall now demonstrate that indeed this has been filed out of time. Paragraph 12 of the record of facts shows that the aforementioned provisions came into force in 2023. That is, the RIEA was amended in 2023, the ERSA was passed in 2023, and the PPRPF was also passed in 2023. Your lordships, the applicants filed this reference, according to paragraph 43 of the facts, in June 2025. Your lordships, in the authority the applicant relied on, that being Omar Awad versus Attorney General of the Republic of Uganda, the court emphasized the value or the need to maintain legal certainty and linked that principle of legal certainty to the 2-month time limit provided in Article 30, Clause 2. Your lordships, allow me to demonstrate the risk that is posed by a reference being allowed out of time. In that case, your lordships, and also in the case of OLA Energy Uganda Limited versus Attorney General of Uganda at paragraphs 44 and 46. The court cautioned that should all references be allowed out of time, it shall open floodgates and the court shall be clogged with references that don't meet the jurisdictional requirements in Article 30, Clause 2. The court also cautioned in the decision previously mentioned that when a partner state signs to a treaty, and the treaty, this case being the Treaty for the Establishment of the Emira African Council, provides for a 2-month time limit within which references may be brought against it. To allow references that fall outside that 2-month time limit would be an inevitable violation of the sovereignty of the respondent state. When we signed this treaty and ratified it, we only envisioned references being brought in respect of policies, directives, or acts that have been passed in at least 2 months. Your Lordship, turning to our responses on personal jurisdiction. The applicants focused their responses on personal jurisdiction on the propriety of the applicants appearing before court. Indeed, we don't contest that the applicants may indeed be valid before court and satisfy the requirements of Article 30, but only partially. Article 30 is prescriptive that the references that may be brought under Article 27 are brought against partner states or an institution or organ of the community. Your Lordships, in the case of Modern Holdings versus Kenya Ports Authority Kenya Ports Authority, the court held at page 10 and 11 that a private entity or an entity that is not a partner state or an organ of the community cannot be sued before this court. Indeed, in finding that a defendant is improperly before court, the court's jurisdiction has thus been ousted. Your Lordships, the question now begs, is Haven Link Limited and Work Link Limited an organ of the community or a partner state? The answer is simple and final. They are not. Your Lordships, turning to the applicant's submissions on the second issue. The applicant's submissions on the second issue focused on whether or not the RIEA, the PPRPF, and the ERSA violate the principles under Article 6D and 7.2. Indeed, we agree with their characterization of the enforceability and the binding nature of Article 6D and 7.2. We don't contest it, for we are predisposed to uphold our treaty obligations. However, Your Lordships, we contest their characterization of our refugee management and service provision framework as being in violation of the same. Your Lordships, allow me refer you to the decision of this court in Manario Desire versus Attorney General of Burundi. In paragraph 73 of that particular reference, Your Lordships, the court strove to define what good governance is. For indeed, good governance sits at the heart of Article 6D and 7.2. The court noted, good governance relates to the existence of mechanisms through which citizens and groups can articulate their interests, exercise their legal rights, meet their obligations, and mediate their differences. It linked this particular definition to rule of law and stated the rule of law demands that all persons, entities, whether the state or other private entities, are publicly accountable to laws that are promulgated, independently adjudicated, and consistent with fundamental rights. That is the standard. Your Lordships, allow us respond to their characterization of our fulfillment of the obligation to promote and protect human rights. The applicants asserted that the framework in question, that being the RIEA, the ERSA, and the PPRPF, encourage or enable outcomes that are inconsistent with fundamental rights protected under the African Charter and other mentioned laws. Your Lordships, however, we wish to rely on a similar authority, Serak versus Nigeria. At paragraph 45 of that judgment, the court was prescriptive that one way a state can discharge its positive obligations with regards human rights is to pass legislation that protects human rights. Your Lordships, allow me demonstrate to you the human rights protections in the PPRPF. The PPRPF in Part 1 binds the implementing partners like Work Link Limited and Haven Link Limited to act in accordance with national and international human rights standards. Your Lordships, further, the ERSA, another law that they contend, also binds the implementing partners, that being Haven Link Limited and Work Link Limited, to provide services that are based on rights. Your Lordships, what this demonstrates, and I believe it is the heart of this issue, is that the abuses are not systemic. There are unfortunate incidences that constitute a breach of our own laws and our own very provisions. Your Lordships, the Constitution of Javari constitutes a robust framework of rights, as is evidenced by Article 38 of the factual pattern. Any acts inconsistent with these rights as established would be a violation of our laws. Indeed, your lordships, the record of facts shows that one of the applicants in this case, that being Center for Refugee Social Equity, has previously successfully challenged the NSMCA before the High Courts of Javari on grounds of its unconstitutionality. Your lordships, that demonstrates that there are effective mechanisms within which the applicants today would have received remedy in the state of Javari. Regarding delay, which also appeared to be a key contention of the references or the cases were filed in January 2025 in the domestic courts of Javari. Following the filing of these three references, the court saw it best fit to consolidate the references into a single case. Your lordships, it begs the question, is it the applicant's position that a complex matter, where the court had to sit and consolidate all these references, in light of all the different administrative challenges that a court registry may ordinarily face, is 7 months an inordinate or extraordinary delay? Your lordships, I would leave that question for you to answer. But in our view, it is not. Your lordships, further, we take great exception to the characterization by the applicants of our position on the rule of law. The applicants contended in their submissions that, in furtherance of this particular point, the applicants sought to demonstrate that the alleged failure, however, as previously highlighted by paragraph 12 by the state of Javari, in paragraph 43 of the facts in October 2025, is in line with the timeframes given in part 6 of the PPRPF. We are following the law to its letter. The applicants cannot characterize our actions as egregious violations of the law. Your lordships, as I conclude on this issue, it's also important to note that the emphasis the respondents wish to place or impress upon this court is that the abuses alleged are not systemic. There are violations of our law for which we have demonstrated, as the applicants themselves, Cresse, filed an application or filed cases in court that have been heard and determined as recently as 2018. A task force has been put in place to listen to the concerns of these refugees and try to provide redress. In fact, your lordships, the very framework before you today is a product of a task force that included civil society organizations, much like the applicant. A clear demonstration on the part of the state of Javari of upholding the principle of transparency and accountability as is mandated to them under the precepts of good governance under Article 6D and 7.2 of the treaty. We are not in violation of our obligations. We have moved in strict compliance with our domestic laws and other international obligations. Your lordships, that said, I would beg to yield the floor to my co-counsel, pending further questions from the bench from my submission.
All right, thank you. Counsel, may I find out whether there is any question from?
I have one question to Counsel Ibrahim. You have made an argument that Haven Link Limited and the other organizations cannot be defined as persons within the EAC. Just wondering, how are they implementing within the EAC and working with the government without any local registration or local something like that?
Perhaps I may clarify, Your Lordships. It is not our position that they are not legal persons within the state of Javari. It's our position that they are not partner states or organs of the community. Article 30 of the EAC Treaty only envisions references being brought against actions of the partner states or organs of the community and not private entities like Haven Link Limited and Worklink Limited. This formed the core of our submissions that two of the respondents are improperly before court, and by this court's ruling in Modern Holdings versus Kenya Ports Authority, the court's jurisdiction is sufficiently ousted in these circumstances.
Presiding Judge, I have one question for Counsel Baraka. You mentioned the 2-month limit, which is the statutory limit. What is the position regarding ongoing violations? Number two, The other side talked about the least restrictive measures as regards about the transfers, and they talked about the transfers were a violation of the non-refoulement provision. What is your response on that? Thank you, Presiding Judge.
Lordships, the position of the East African Court of Justice on the 2-month time limit is quite clear, especially as concerns continuous violations. In the singular case where the court recognized continuous violations, that is Plaxede Rugumba versus the Attorney General of Rwanda, that very case was appealed and the appellate division of the court held that doctrine does not have basis in this court. Your Lordships, that particular position has been repeated in cases such as...
Sorry, Counsel, what authority was that?
That was Plaxede Rugumba versus Attorney General of the Republic of Rwanda.
Okay.
That position has been repeated in Omar Awad versus the Attorney General of Uganda, OLA Energy Limited versus Attorney General of Uganda, as well as Attorney General of Kenya versus Independent Medical Legal Unit. Your Lordships, concerning the transfers breaching the principle of non-refoulement, as my co-counsel shall submit, but I'll also highlight, the transfer of refugees to Ulukari does not in any way put their rights at risk. Indeed, the principle of refoulement, of non-refoulement, seeks to bar. Your Lordships, I recognize my time is up. I'll request 1 minute to wrap up my answers to his Lordship's question.
Go ahead.
Most obliged. The state of Ulukari has an RSD process that mirrors that of Javari. Further, Your Lordships, the state of Ulukari is a party to the 1951 convention relating to the status of refugees. What this demonstrates, at the very minimum, there is a legal framework within the state of Ulukari to protect the rights of refugees, and any breaches of the same may be adjudicated sufficiently. Most obliged.
Thank you very much. Right.
May it please this honorable court, my name is Namanya Christia Abigail, second counsel for the respondents, and I have been accorded 15 minutes of this honorable court's time, and I shall use them to address issues C. Issue C concerns whether the restriction of Class C work permits for the EA is demonstrable, measurable progress that is attributed to the state of Javari. Your Lordships, the applicants misconstrue a temporary administrative challenge as discriminatory exclusion. Your Lordships, we respectfully submit that Javari has consistently maintained access to these Class C work permits, evidenced by over 50,000 successful job applications and the reported improved living conditions. Your Lordships, this establishes that there is no blanket ban or policy restricting the economic participation of these refugees within the state of Javari. Similarly, Your Lordships, these delays arise from unprecedented and administrative strain caused by the 5.6 GDP contraction, the 83% collapse in its services sector, as well as the 58% reduction in international aid. Your Lordships, in these circumstances, Javari was permitted to regulate labor entry on grounds of economic necessity, as well as public policy in saturated sectors where citizen unemployment was acute. Your Lordships, the state has also established an interdisciplinary task force under paragraph 43 to address and confront the plight of these refugees in order to ensure that the work permit system evolves in a way that enhances their dignity and economic inclusion. Your Lordships, perfection cannot be the legal standard for a state hosting more refugees than any state within the region of Emara. Your Lordships, what matters is the state of Javari is progressively realizing the right to work under good faith efforts as fast as its economic reality can allow, not as fast as its economic system permits. Your Lordships, this demonstrates Your Lordships, this demonstrates not discrimination, but ensures that the state of Javari has ensured and protected the right to work for these refugees. Your Lordships, I'll now submit on issue D. Issue concerns whether the transfer of refugees to the state of Ulukari violates the principle of non-refoulement as established by the applicants. Your Lordships, we respectfully submit that the transfer of these refugees to the state of Ulukari does not violate the principle of non-refoulement under international refugee law. Your Lordships, the applicants established that the state of Ulukari, under the Ndukara and Bakama camps, has violated the principle of non-refoulement under international refugee law. Your Lordships, we respectfully submit that the applicants have misapplied the facts. Your Lordships, paragraph 16 establishes that these Ndukara and Bakama settlements are located within the state of Javari, not the state of Ulukari. Your Lordships, we respectfully submit that these asylum seekers are transferred, particularly to the city of Uwezo, where the facility is established for these asylum seekers and refugees. Your Lordships, any arguments raised by the applicants concerning the Ndukara and Bukama settlement camps do not suffice because the state of Ulukari is not where they're designated. Your Lordships, that these asylum seekers as well as refugees are transferred to a facility in the city of Uwezo within the state of Ulukari. Your Lordships, secondly, it is important for me to highlight that the case of Hasi Jama versus Italy, application number 29965/09, before the European Court of Human Rights, highlighted under paragraph 147 that it is the responsibility of the state transferring these refugees and asylum seekers to ensure that the receiving state provides adequate safeguards. Your Lordships, respectfully submit that the state of Javari has ensured that the state of Ulukari has adequate safeguards to ensure the protection of these refugees. Your Lordships, it is important for me to highlight that according to the guidance note on bilateral and multilateral transfer arguments of asylum seekers, paragraph 3 VII, as established by the applicant, establishes that the receiving state must provide effective protection for these refugees by ensuring that they shall not be refiled against and by ensuring that they have access to fair and efficient asylum procedures and that they have adequate reception conditions. Your Lordships, the fact pattern indicates that the state of Javari has ensured that all these are in place. Your Lordships, it is important for me to highlight that paragraph 14 of the instant facts establishes that the state of Javari has provided adequate reception conditions. Your Lordships, this is illustrated by the committal of $80 million in order to facilitate the development aid within the state of Ulukari, as well as the $600 per person to cover a 3-year integration package. Your Lordships, we respectfully submit that the state of Javari has ensured that the state of Ulukari has adequate safeguards for these refugees and asylum seekers that are transferred there. Your Lordships, the applicants raised a point on the Uwezo detention facility. And they established that because it is a detention center, it does not permit the free movement of these refugees as well as asylum seekers. Your Lordships, allow me to establish that paragraph 15, establishing the Uwezo detention facility, establishes that it is heavily monitored and that residents are not permitted to leave until their claims are resolved. Your Lordships, we respectfully submit I beg your pardon. Your Lordships, respectfully submit that according to the UNHCR guidelines on the applicable criteria relating to the detention of asylum seekers, it is necessary for 3 main purposes. Your Lordships, it establishes under paragraph 12 that it is necessary for public order to prevent the absconding or cases of likelihood of non-cooperation, and it is also necessary that to establish that these periods in detention may also be permissible to carry out initial identity as well as security checks in cases where identity is undetermined or in dispute. Your Lordship, similarly, restricted movement does not make the state of Ulukari unsafe, particularly where it is a standard feature of responsible asylum screening. Your Lordships, this is important to establish that those who are actually refugees are in dire need of this protection. It is also important for me to establish that according to the National Security and Migration Control Act of 2018, that applies the same RSD procedures as the state of Ulukari. Your Lordships, Part 2 as well as Part 3 indicates that all detentions in this case shall be temporary in nature and that they shall be subject to a periodic review by the National Migration Oversight Board, an independent administrative body composed of representatives from the Ministry of Interior, Ministry of Justice, as well as the National Human Rights Commission. Your Lordships, the state of Javari has ensured adequate safeguards within the state of Ulukari to ensure and prevent the refoulement of these refugees from the state of Ulukari. Your Lordships, we respectfully submit on these averments that the state of Javari has not violated its obligation to ensure the principle of non-refoulement under international refugee law. Your Lordships, in light of the above submissions, we respectfully submit and we pray that this court adjudges and declares that the Emara Court of Regional Justice lacks the jurisdiction to hear matters brought before it under the EAC Treaty, and that the RIEA, the PPRF, as well as the ERSA do not violate Javari's obligations under Article 60 and 7.2 of the EAC Treaty, and that this restriction of Class C work permits does not violate Javari's obligations under regional and international law, and that the transfer of these refugees to the state of Ulukari does not violate Javari's obligations under international refugee law. I beg to submit.
Oh, thank you very much, Council Manya. One question or clarification from you.
Yes.
I'm sure you are familiar with
Rugomba.
Rugomba, appeal number 1, isn't it?
Yes.
In your view, how does that authority apply in this case with regard to the crisis situation in Johari?
Much obliged, Your Lordships. Your Lordships, this case applies because the state of Ulukari, the state of Javari, I beg your pardon, has ensured adequate safeguards to ensure that the principles under Articles 60 and 7.2 are established. Your Lordships, it has ensured adequate safeguards established under these legal frameworks that have been amended and enacted by the state of Javari to ensure governance, as well as ensure the protection of these refugees within the state of Ulukari. Yes.
Thank you.
I have a question. You've made reference to UNHCR guidelines.
Yes.
It skips my mind what the justification was, but I'm just wondering between international law and UNHCR guidelines. International law is binding, UNHCR guidelines are not binding.
Yes.
What's your comment on that?
Much obliged, Your Lordships. Your Lordships, in the statute establishing the UNHCR, under the UNHCR paragraph 1950, Your Lordships, paragraph 8 as well as paragraph 1 establish that the UNHCR shall have a supervisory authority in order to ensure that these establishments within the Refugee Convention are abided by the states that have signed up to the 1951 Refugee Convention. Similarly, the UNHCR has been mandated by the UN General Assembly under paragraph 1 of this same statute to accord international refugee protection to refugees around the world, and also establish a permanent solution to this problem of refugees in order to ensure that these administrative bodies as well as states ensure this adequate refugee protection. Your Lordships, much as it is not binding, the supervisory nature of the UNHCR allows and establishes relevant refugee protection. Yes.
That's a follow-up question.
Yes.
What is the legal status of the statute of UNHCR of 1950?
Much obliged, Your Lordships. Your Lordships, much as it is not binding before this court, the UNHCR has established several guidelines, advisory notes, as well as guidance policies in order to establish the protection of refugees. Much as it is not binding before this court, Your Lordships, it is a persuasive authority before this court in order to establish relevant refugee protection as established under the statute of the UNHCR of 1950.
Presiding Judge, I have a short question. You talked about resource constraint and you said that
Yes.
they are doing it progressively.
Yes.
Is that argument absolute? That once the state says we don't have enough resources or we are doing it progressive, that's it?
Much obliged, Your Lordships. Your Lordships, it is not absolute. However, we recognize that according to the SERAC versus the Commission of Nigeria, it established that the right to progressive realization encompasses resource constraints within the states that are establishing this refugee protection. Your Lordships, the states has taken deliberate and concrete steps to ensure that this right to work is guaranteed by the state of Javari. Your Lordships, this cannot be set aside by the court before us. Your Lordships, the economic reality within the state of Javari mandates that it progressively realizes the right to work amidst resource constraints within the state of Javari. Your Lordships, as I respectfully submit that perfection cannot be the legal standard for a country hosting more refugees than any other state within the region. Your Lordships, what matters is the state of Javari is progressively realizing this right to work as fast as its economic reality allows, not as fast as its economic system permits. Your Lordships, that encompasses not discrimination, but regional integration. Your Lordships, I beg to submit.
Thank you very much. Thank you. Right. Oh, sorry. Looks like one more intervention. Please go ahead.
Sorry about that. My question is in regards to your argument that Ulukari has safeguards, the transfer to a third state.
Yes.
Article 3.2 of the OAU Convention, the 1969 Convention, expressly prohibits a state from turning away an asylum seeker. What's your comment on that? Because that appears to be what's happening in this case. Thank you.
Much obliged, Your Lordships. Your Lordships, it is important for me to establish that the UNHCR does not establish that transfers to safe third states are prohibited. Your Lordships, the administrative capacity, as well as these resource constraints within the state of Javari mandated.
The OAU Convention.
Yes.
The OAU Convention is what I'm asking.
Yes.
Not the UNHCR, but the OAU Convention.
Much obliged, Your Lordships. Your Lordships, respectfully submit that the OAU Convention does not prohibit the transfer of refugees to safe third states. Your Lordships, we have not turned away these refugees that are being brought to the state of Javari. Your Lordships, our administrative and resource constraints have mandated that in order to establish this refugee status determination amidst our backlog, our RSD backlog within the state of Javari, we have established that these refugees need to be transferred to the state of Ulukari in order for their refugee status determination claims to be asserted amidst our administrative backlog within the state of Ulukari. Your Lordships, I beg to submit.
Thank you very much. I think we're satisfied. Now, we turn to the applicants. You have amendments for agenda, 3 minutes. Please go ahead.
Judge, President, distinguished members of the bench, it's an honor and a privilege to appear before you once again. My obligation here is simple and straightforward. We have 1 point of rebuttal regarding the obligations of Javari and Article 6D and 7.2 of the EAC Treaty through the implementation of the ERSA, the RIA, and the PPRPF. However, before I turn to my rebuttal, we take cognizance of the fact that the respondent state has misconstrued our cause of action and Article 30, Sub-Article 2 of the treaty. The respondent state has challenged temporal jurisdiction on the basis that the RIA, the PPRPF, and the ERSA were enacted 2 years before this matter came before this honorable court. However, before we begin our submission, we contended to this honorable court that our contention is not about the enactment of the RIA, the PPRPF, and the ERSA. Our case was about the Republic of Javari's subsequent failure to provide effective remedies arising out of the implementation. We sought to rely on the case of Mother Karua versus Attorney General of Kenya, where this very court held that the failure of the state to act through its judicial machinery constitutes a cause of action, and we urge this honorable court to take note of the same. Turning to my rebuttal, members of the bench, the respondent state has vigorously submitted the establishment of the task force on 7th October 2025. Constituted the right of access to justice. However, allow me to direct this honorable court to the case of Aiden v. Turkey, where the European Court of Human Rights found a violation based on an unreasonable and a prolonged delay of the judicial omission after a formal complaint. The respondent's conduct echoed the same. through the systematic failure of three judicial organs, through the systematic failure of three organs, the Ombudsman, the Ministry of Humanitarian Affairs, and finally the High Court of Jaffa. The right of access to court is a crucial right concerning matters regarding right and liberty. If this honorable court were to turn a blind eye to this blatant violation, refugees like Amina, Fatima, and Samuel Lamini will continue suffering in the hand of the Republic of Jaffa, a country that promised their safety. The applicant rest.
Thank you very much.
Kindly, let's clear the courtroom so that the judges can deliberate. Let's do so quickly. Let's move kindly. Just wait outside for 5 minutes for judges' deliberation.
Are we expecting other person?
We can proceed.
That is all?
Yes.
I see very few in the room, but okay, we can proceed. Sorry? So we give our time or 5 minutes? Okay. The applicant's counsel is going to pray. We give her 5 minutes. Yeah, the applicant's counsel is going to pray, so we give her 5 minutes. Yeah, that's fine. I see. Okay. Okay. We are waiting briefly for the applicant's counsel because we have to respect our right to pray, but she's coming back in a little while. So just bear with her for about 5 minutes. No, it's okay.
You can proceed.
Yeah.
Then for the photo session, the teams will come and stand behind you.
Okay. Okay. Okay, may I now call the court to order? Let me start by saying that the brief remarks that I'm going to make are collective remarks of the entire bench. And on behalf of these distinguished judges, I would like to thank both teams for doing very well. You are excellent. I must say that I have been here before to conduct a final of other moot courts, and I think, without a doubt, I keep seeing excellent presentations. As one of us remarked, and rightly so, that even reaching the final, that in itself is an excellent achievement. And we want to congratulate you for your very good presentations. We really appreciated your collective effort. We saw a very good art of advocacy that was demonstrated by the two teams. Very good timekeeping, both sides. Very good. We did not have to ask any counsel to sit down. Only when we asked quite a number of questions was there a genuine request for 1 more minute. The timekeeper, you did very well also in that regard. We really commend you. When, as counsel, you stand before a court, be as real as possible, because you're not here to impress anyone or to act. It's a real situation. And if you have to quote a particular portion of the law, do so accurately, unashamedly, because at times there is power in actual quoting of an actual case, a section of the law. And when you cite an authority, please cite it accurately, give the details of the court that render that decision. If it has been distinguished, be candid enough to say so. And take time to explain distinguishing authorities, as I've indicated. Keep practicing. Practice makes perfect. We have seen budding legal tactics and presentations that need to keep on being honed, and you go far if what we have seen this afternoon is anything to go by. When you ask questions by the court, if you have to make a concession, do so. Do so. Sometimes the law may simply be against you. You can make a concession and then see whether you are able to distinguish, or rather distinguish the situation so that you are able to show the bench that you are not phony, you are real. You admit that that particular situation or the question put to you may be against your case, but perhaps there's another argument that you can advance to counter the weakness in that particular question. But it's important to make a concession if you have to. In strategic litigation, as this one was, no doubt, ensure that you not only grasp the law, but also appeal to the court's motion. The court, these judges are real. They do not live in Mars. We live in the same world. And so make sure you also appeal to their emotion, even as you do so in regard to their reasoning capacity. One thing I would like to say is that a court should never have to struggle to hear what counsel is saying. Always make sure that you are clearly audible. Don't fumble at all. If you have to shout, shout. Of course, we are not encouraging you to shout. All we are saying is make sure that the court is getting you clearly. The moment a judge tells counsel, pardon me, I can't hear you clearly, it's not very good. Your confidence and poise in court is very important. And this one, we truly commend both teams. All of you had very good confidence, and you commanded the court very well by your poise. I do not want to say more than that, other than to congratulate both teams once again. You've done an excellent job. You have represented or depicted the true spirit of the East African, cooperation. We were very impressed by what we heard this afternoon. And we believe that across East Africa, we have great lawyers in the making. If what we have seen represents what we have in our law schools, and we believe it does. So thank you very much. We appreciate.
Thank you so much, Justice Musinga. I think before we leave, it's important because our boss and our host is here. But before I invite her, the Dean of Strathmore Law School, mine is to thank you for just to have, I have immense gratitude, I think, to what has happened over the last 2 days. And we've made all this, we've all made this a true success. The judges, thank you for your time. Your wisdom and your rigor, the comments already show what it took. And the thoughtful question and generous mentorship. And many of you, I think those who I have taught, just see Professor Abuya here, but if he tells you the story that he walked me through in University of Nairobi, for me to be a refugee researcher, it started there in 15, almost 15 years ago, when he was my supervisor. So you have shaped this next generation. Whoever has won, whoever has participated in this competition, you have really mentored them and shaped them. Our appreciation goes to you, Justice Musinga. I think your continued friendship to Strathmore Law School, you've always showed up to mentor our students, and you've always supported the advancement of legal education in whatever way, whether it's lectures, Moot, and these have meant more than words can convey. So as always, you honor us with your presence and leadership. To the distinguished final bench, Honorable Burugu, Professor Abuya, Damaris, Professor Rutinwa, Tuhairi, Dr. Nyaruiru, and Professor Mayambala. Thank you so much. Thank you for, some of you have been through the preliminaries, quarters, semis, and finals, and we're grateful. And this expertise has helped set a high bar, and our students will carry this guidance to them. You can see many banners here. In Komoko, Reds, NRC, Amahoro, RCK, HBS, DRS have walked this journey with us. And thank you for believing in this vision. I'd say that when we were opening, I used to go pitch to them, tell them we need this money, we need to fly teams from Uganda and Tanzania. And of course, people thought I was mad, but here they are. To the teams, coaches, and institutions represented here, you have set a pace for this inaugural Moot, and we hope you don't just leave with awards, but with a renewed purpose when you go back home. So of course, we won't announce any results today, sadly, at this point. We shall announce them at the closing dinner in the award ceremony at Emara Ole Sereni at 6:30, which will be an evening of celebration, connection, and well-deserved recognition. So until then, happy touring for those who will tour a bit for a few hours and resting before we meet for the final aspects. With that, I would like to invite the Dean of Strathmore Law School, Dr. Jane Watuta, to give her remarks. And after she does that, you can clap for her, she comes. After she does that, we would like to request both teams, together with the coaches, to come behind the judges to have a photo session. And then after that, we will walk out with the judges and we release everyone else. But we invite you for lunch downstairs, where we usually go for our meals. Dean, karibu.
Thank you so much, Alan. Good afternoon, everyone. I'm so happy to be here. I'm glad to be able to participate in the closing ceremony. A few people have asked me, or have told me, I thought you were in Narok, because I was in Narok the last 3 days. I have to say it's a busy 2 weeks for the law school. We're on a media break of 2 weeks between exams and the beginning of the second semester. And I'm so glad that there's a lot happening at once, so to speak. So in Narok, we've had to, just for anecdote and perspective, we've had one group doing what is called the Narok Civic Initiative, led by our lecturer, senior lecturer, Dr. Antoinette Kankindi. She was there with a good number of students, helping to renovate a school. It's called Enengetia Primary School in Narok North. And also they ran a tuition program there. So they were there in two different groups because of the numbers. And then almost at the same time, almost concurrently, there's also what we are calling the Legal Aid Caravan, the 3rd edition, where our law clinic is out there giving legal advice to the communities in the Narok East and Narok West part of the county, together with our partners. This time we were joined, in fact, by partners from 2 universities, Stellenbosch University and also Notre Dame University. The head of their clinic there came with 2 students, and they even sponsored, they gave a donation of 1,000 USD to one of the local schools for some refurbishment that needs to be done. And we also have Konrad Adenauer working with us in this caravan and others. So it's a great time for the law school. So needless to say, this event now that is coming to a close has been also a major highlight in our calendar, and especially in its inaugural phase. Yeah, it's a great occasion, as Alan has said, what started, if you want, as a dream, as a plan, and we know we went through some moments of suspense and even anxiety, wondering whether our Tanzanian counterparts would be able to come. It's so good that the roads opened and the skies, and that you were able to join us. So I'm really honored and happy then to, of course, address our distinguished guests with a special thank you to Honorable Justice Daniel Musinga. We are so grateful for your being here and for being presiding over this panel that closed this Moot. And also to congratulate everybody who has participated, in a special way, of course, Alan Mukuki and his team at the Forced Migration and Displacement Hub that is going places already, and this is great. The future is really bright. Also to our students for your hard work, your research, your advocacy, your passion for justice. To our judges, our panelists in the different sessions and rounds that happened over the 2 days, coming from academia, from the judiciary, from the international institutions, and in absentia to Dr. Chaloka Beyani. I have to say, I've only gotten to know about him now, and I'm glad I've gotten onto that bus, where I'm not the only one who may not know, at least in this forum, and related forums, who this great person is, a great African who is doing good work, and then it makes a lot of sense, therefore, that we would name this first Moot after him. And of course, we identify ourselves. Yeah? We align ourselves with the goals and the efforts that are being put to address the plight of refugees in Africa, knowing that 30 million of the over 100 million are in Africa, and that these are men, women, and children who remain vulnerable, who need protection. And we know we have these large camps in Kenya and also in South Sudan and in the Great Lakes region. So for us as educators and as lawyers and citizens in general, we want to help one another if you want. We want to spread the word out there that it's important to know refugee law and to not only know it, but also live by its principles, compassion and human dignity. We know and appreciate, I'm sure, better through this Moot competition that their economic rights are important, their right to work, and of course, these have been very ably argued. Yeah, I was glad to be able to listen to the final round, to hear our students here articulate, or the council, articulate the economic rights, the right to work. So this Moot is more than just an academic exercise. It's helping us bridge theory and practice, even as at least at Strathmore Law School, we prepare to offer this unit. Refugee law from next year will be an elective, but I know there are people who are waiting for it. And I was talking just briefly to one of our alumni who was a judge in the previous rounds, Philip Ogonda, and he was like, yeah, I wish we had gotten to do refugee law in our time. Whatever the case, he has gotten into that space and is doing well. But we are, of course, really happy that the students coming after them will be able to take this course as part of the LLB program. And of course, we also hope to offer executive education courses in this area as well, as we've already started to do since last year. So we want to equip our students with the knowledge and the skills that are needed to address the plight of refugees and displaced persons. So in conclusion, may this competition remind us that the measure of justice is how we treat the least, the weakest, if you want, the most vulnerable. And may we leave this venue, this occasion with a renewed conviction that through our legal scholarship and through our advocacy, we can make a difference one at a time to the millions of refugees that are affected, even just in our part of the world. So on behalf of Strathmore University and the law school, I wish to congratulate all the participants, all the organizers, the partners. We are really grateful for the collaboration. And allow me to leave you with a quote from the founder of Strathmore University that we like to invoke every so often, St. Jose Maria Escriva. I think this quote speaks very well to the dignity of each and every refugee. He said, "Each soul is a wonderful treasure. Every man is unique and irreplaceable. Every single person matters to God." So may we go out there and tell every refugee that we meet, and as we engage in refugee work, that every single person matters, that each soul is a wonderful treasure. Thank you so, so much.
Thank you, Dean. Let's clap for her again. I think we just need to conclude. So I'll invite the applicants team for a photo with the bench. Applicants, then respondent, then both. Both. This can stand at the center so that we have, yeah. Yeah. So you can prepare. Yes. So we'll have the first photo. Okay, thank you. You can wait on the edge there, respondents. Yeah. Applicants, you may join the respondents on stage so that we have both teams. Yeah, both teams, yes. We were taking the individual, yeah. Thank you so much. As they exit, I think this is the point where I say all rise as the bench leaves.